Good afternoon, everyone. Thank you for joining us for this session on charities and intellectual property. I'm Shivaji Shiva, a charities partner at VWV, where I help people form charities, close them down, and do most things in between. And I'm here with Sarah, who'll introduce herself.
Thanks, Shivaji. And I'm Sarah Webb. I'm a partner in the commercial team at VWV, and I do a whole range of commercial agreements for our charity clients. So supplier agreements, sponsorship agreements, licensing agreements, collaboration agreements, all the IP licensing and assignment arrangements, and also support the wider team in any mergers and acquisitions involving the charitable organisations we act for.
Brilliant, thank you. And so moving to the what, as you heard earlier, this session is about intellectual property. And I'm assuming that anyone who clicked in by mistake will have slipped away in the way that you do. And Sarah's going to put the experience she's just described towards taking us through the key things that charity trustees and leaders need to know about intellectual property, and taking a look at some of the practical ways in which you can safeguard that intellectual property and make the best use of the assets represented by it. I'll perhaps contribute occasionally some thoughts from the wider sector. So, which leaves us with why are we doing this? And that's because many of our clients tell us that they're less familiar than they might be with intellectual property rights, and particularly with the process of identifying, protecting and exploiting IP, because that's not historically been a priority for charities. Because this is very much an introductory session, a bit of an overview of the rights that you need to be aware of. And a very practical look at intellectual property rights. We'll try not to get mired in the detail. One of our key aims this afternoon is to identify the key IP rights for charities. We don't have time in this session to look at absolutely all of those rights. In your experience, what are the key rights that people need to be aware of?
So in my experience, Shivaji, and the most important thing for me from the outset for our charity clients is to be able to pin down your IP assets, identify what they are. And there's a whole range of IP rights, some protected by registration, some protected or unregistered rights. And the two ones that keep cropping up in my experience are trademarks, which you won't be surprised to hear, the brand and the name, the logo and the get-up, and also copyright. So charities have copyright in their annual reports, research, marketing materials, training materials, IT infrastructure. So those are the two most important ones, but we mustn't forget that there are others. We've got designs in there as well. We've got patents, we've got domain names, database rights is another important one, I think, for charities. And then, of course, there's confidential information know-how, which is a softer IP right, which is we need to look at how we can protect that too. We shouldn't forget that.
Absolutely. So if I'm hearing right, with the distinctions you're making are between those rights which you have to register yourself, just to do something in order to get the rights, those which are unregistered and arise automatically, and then within that space, you're saying the two key areas are copyright, arising automatically in all sorts of things that are listed there on the slide, and trademarks, where what you're protecting is the name, the logo, perhaps project names and the like.
On the whole, Shivaji, yes, that's correct. But obviously, if we've got a charity that's in the medical or scientific sector, they're going to have extensive patent portfolios, and there's a whole different that's a whole different webinar. But I just flag that. But it just
absolutely. So there's lots of different rights, whether they're unregistered or registered, design rights, all of those things. But we're going to focus primarily on those two areas, and perhaps a bit about confidentiality and know-how. Gotcha. Okay, so if we then dive across to the next slide, and I ask you, we're clearly looking at brands here, so I'm guessing this is about trademarks, which leads me to the question, charities aren't out primarily to make a profit. Why would they care about trademarks?
That's a very good question, Shivaji, very good question. Well, it's reputation. I mean, securing a trademark is absolutely imperative as far as I'm concerned, because over a period of years, my charity clients have built up their reputation, they've built up their profile, fundraising, they've invested time and resource in developing what they're all about. And actually the brand is right at the heart of that. I mean, you would not insure your property, would you, and protect your property? So why would you not look after this core asset at the heart of the charity? And the second point, of course, in relation to me saying, if you can register it, please do, is it's so much easier to enforce and protect if you have a registered right, because it's scoped clearly and there's legislation dealing with it, which makes it much easier.
Brilliant. And just to kind of reinforce that piece about the cost and the reputation, in kind of preparing for this session with you, I was looking at some of the bigger trademark cases and other intellectual property cases, and one that lots of people will know is the one involving the wildlife charity WWF, which was about 20 years ago now. I'm horrified to realise.
Before my time, Shivaji, of course.
I understand that, but when the World Wildlife Fund for Nature, or WWF, won a battle with the World Wrestling Federation, then WWF, now WWE, because the wildlife charity won. And the reason I'm mentioning it is that I was interested to see that at the time, so 20 years ago, the Federation estimated that if it had to change its name and do a rebranding exercise, it would cost it £35 million, which I think gives a sense of the value sat behind trademarks.
Yeah, absolutely spot on. Absolutely. Yeah.
And then if we go back to this slide that you've got up about brands, I'm assuming that there's a distinction being made there between words, logos, and devices. Do you want to say anything more about that?
Yes. I mean, I'm not, just a quick disclaimer here, I'm not a trademark agent, so and I'm not qualified to make trademark applications. You've got Paula for that, who's superb, Paula and her team. But my advice would be, and based on my experience, is really to get the scope of the trademark application as wide as possible to cover what you're looking at. So invariably we're looking at brands we've got there. If we're using children in need, we're using BBC Children in Need. We've got the little, is it Pugsy Bear, isn't it?
That's right.
Yeah, and make sure that everything is covered, and that is really we need. I think my point here is take it seriously. Don't just a lot of clients come to me, just get a trademark off quickly, but actually think about your future use. Think about what jurisdictions you might be wanting to use it in. So so there's
an important piece to be thought through about whether you go for a word mark, which might be a bit broader, but might be harder to get through. Whether you go for the logo itself and that image, or for individual devices within that. I Correct. Can see that. Okay. Yeah. And that kind of leads us to the next question, really, which is, how does a charity protect its trademark? What are the steps there?
So a trademark can be registered if it's capable of being recorded on the register. There was a change recently that Shivaji and I were talking about this morning, in terms of previously it was if it was capable of graphical representation, and that's now been extended. We'll pick up on that later. It cannot be inherently distinct descriptive, which actually is common sense, really, because it's therefore by definition not distinctive. But that's a very, very important point. So make it as distinctive as you possibly can. As I've said,
this is the point. Sorry to interrupt there, Sarah, but this is the point that many of the charities that we know begin with names that just describe what they do. So the Oxford Famine Relief Committee just describes what it does. Oxfam is a more distinctive name. And although, as I understand it, and again, I'm not a trademark specialist, there are particular rules about identifying organisations with trademarks, which mean that sometimes even a moderately descriptive name can be used. The point you're making is that the stronger mark comes from being more distinctive. And sometimes there's a minimum level of distinctiveness that's required if a trademark's going to be registered at all.
Correct. Yeah.
Brilliant.
Yeah. So, and then obviously check you cover all the classes of goods and services that you're interested in trading in. And actually a bit of a horizon scanning as well is helpful here. So I had a client actually years ago who decided to move agenda, and they hadn't covered it, and then it was all settled in the end. But these are all things that we should be thinking about from the outset, a bit of planning. And then of course goes without saying, do a proper full availability search of the trademarks register. And then my last point on there is about think about who should be applying for the registered trademark. Should it be the charitable organisation, or should it be the trading subsidiary? This is something that Shivaji and I will pick up later in the licensing, because it's relevant to the licensing arrangements and where it might sit in the context of the charitable objects.
So there's an initial conversation about which entity might be doing that registration, and as you say, we'll come back to that. And so that's all about applying to register a trademark, so a registered mark. And what if a charity finds that another organisation is misusing its name or its logo, but the charity has not yet registered those marks? So perhaps it's got a long-standing name or logo, but it hasn't registered it yet. It's all lost?
Okay, so no, all is not lost, Shivaji, because we have the good old tort of passing off that's been around for years since the Jif Lemon case, which you might remember from
Emily.
Yeah. So what is absolutely key here is to be able to demonstrate established goodwill and reputation. So make sure you keep a log of your marketing spend, you know, the use of the logo, and that will all come through evidentially in court. I must add, actually, I have tried to run passing off cases in the past, and they are not easy from an evidential perspective. It's quite a challenge. So the more you can do your thinking ahead of time, the better. So keep a record of your marketing spend. You establish goodwill and reputation. You've then got to be able to demonstrate there's been a misrepresentation by another party that therefore results in the association of goods or services with your brand, and that causes confusion. And as a result of that confusion, there's damage to your goodwill and reputation, which is at the heart of passing off. Some years ago, it was thought that this couldn't actually apply to charities. It was just on these sort of trading businesses, trading entities that weren't charities. But the British Diabetics Association, which is a famous case that Shivaji and I know all about, that got rid of that, didn't it? Made it quite clear that charities could argue passing off and rely on it.
Absolutely.
Shivaji, you tell us a bit about it.
I'm not going to try and take time up with the details of the case, except to say, I think, two things. One is that it was a passing off case that arose out of a dispute between two charities in the same area, as you see from the name, the British Diabetic Association and the Diabetic Society. And that came about because you had a really successful fundraiser for the one, deciding that he no longer felt comfortable working with them and going off to do his own thing and raise money and set up a new entity. And I think most people in the charities world will recognize that scenario, and the aggrieved former supporter who splits off and goes off and does something very similar elsewhere. So it's a reminder of the importance of thinking about names and thinking about protecting names. Going with that is that there was a really important caution in the judgment to the case, which is a caution about the costs that can arise when you're pursuing passing off, which is generally more expensive because it's more complicated to demonstrate all of those elements of passing off than it is to simply waive a certificate for a registered trademark and tell people that we've got this statutory monopoly over the use of the name or mark. And what the judge said was, and bear with me, it's only a couple of paragraphs, a passing off action by one charity against another is, on the face of it, a deplorable, even scandalous thing to occur. Charities solicit donations from the public in the expectation that donations will be well spent on furtherance of the charity's purposes. Even for a lawyer, Sarah, it's a difficult mental feat to recognise this very expensive litigation as helping those whose subscription and gifts will be the ultimate source of payment for the lawyer's bills. And I think that just underlines that risk of the deplorable, even scandalous expenditure of money, underlines the concerns that many of the clients that come to us have about balancing the cost of protecting and exploiting intellectual property with the benefit to the organisation.
Shivaji, if I could just echo that, I mean, I think litigation, in my view, has to be the last resort for a charity. And some of the recent cases where I've been reading, again, it's all linked to passing off, not dissimilar to this case in terms of a breakaway, a client in the adult education sector. And I think the judge has said it was lamentable that the costs had, it was over 400,000, almost $500,000 had been spent that was not going to be invested in furthering the charitable objects, but instead had gone to pay the lawyers. I mean, and it's just not really what it's about. So it should very much be a last resort. Or why the parties couldn't settle before then, I don't know, but it is very much a last resort.
Absolutely, and I think most lawyers working within or with charities will have experience of having read the Daily Mail article that follows a dispute like this, listing the extraordinary expenditure and implying that it had all been paid directly to lawyers and wasted enormously. Actually, I think there's another famous example that I remember well, which is the Diana Memorial Foundation. So this is the foundation set up after Princess Diana, as she was, had died. And without going into the details of that, the trustees ended up suing Franklin Mint in America for copyright infringement, I think it was. And the result was both fear on the part of trustees of an unincorporated charity that they might be personally liable. Andrew Hine, former chief executive of the Charity Commission, has written really vividly about the feeling that the costs were getting out of control, but also a number of press articles pointing to the expenditure of millions of pounds on a lot of legal fees and contrasting that to the amount spent on the purposes of the charity. So I think it is very clear that there's a real risk there. And I think if I've understood you correctly, Sarah, that the thing that you're highlighting is that people could go through the housekeeping exercise of registering trademarks as a way of reducing the risk that they'll be in that space of having to use unregistered rights.
Exactly so. So Section 10 of the Trademarks Act, infringement, if you have an identical or substantially similar use of a trademark, is so much more straightforward. Shivaji, evidently, you know, it's a different ball game. So really, and the same with patents. If you've got an invention that could be protected, get it patented. If you've got a common to design rights, but if you're in the unusual situation where you're producing products that might or manufacturing something that might attract design right, again, get it registered. My recommendation would always be to get a monopoly right through the registration of that IPR.
So a strong endorsement for registration where it's appropriate.
Yeah, absolutely so.
Okay.
Absolutely so.
And the other key right you mentioned, in addition to trademarks, was copyright. What should charities know about that?
So copyright arises automatically, as probably a lot of you will know, and it protects original artistic, musical, dramatic and literary works. Now, in terms of a charitable organisation, this is going to be your marketing materials, as I mentioned, your training materials, your research, your donor details of your donors, anything that is committed to a tangible form. It will arise automatically. Copyright will arise automatically in it, and as long as you can evidence its creation, you'll be able to enforce that. I've made a point there that it doesn't protect the expression of an idea. So an idea that's not committed to tangible form will have to be, it can't be protected. The other point as well, I think, is worth noting in context of copyright is moral rights. So if you're in a collaboration, for example, with an academic who's working with you on a research piece, and you produce a piece of work, I've had a number of cases this year where the academics have come back and said, well, actually, you haven't identified me as the author of that piece. So moral rights, for those of you who don't know, personal rights that follow the copyright. And a couple of examples is the paternity right, the right to be identified as the author, and then the right to object to derogatory treatment. So if you mess around with that person's work, and you don't want that hanging over you in the future, if you can ensure that if you have any contractual arrangements with individuals, that these moral rights are waived, because they're personal rights, they have to be waived. You can't assign them. Don't know if that's covered. Gotcha. Does that make sense, Shivaji?
It does. So we've got this wide range of things that can be protected by copyright. The rights in that arise automatically. And then you've got these specific additional rights that some of us will be less familiar with. Yes. Including moral rights and some of the things that go with it. Okay.
Yeah, the other thing I should just quickly mention as well, because it's something that's come up during lockdown, when online lecturing and online training has become the norm almost. Obviously, we're hopefully coming out of that more of a hybrid mix. So and I won't go into details on this because it is quite complex, but it might well be that the individuals or the experts giving the lectures or the training are in fact delivering a performance. And the performance in itself attracts additional rights, and it's a matrix of rights. So you've got property rights, which can be assigned. So that's pretty straightforward, relatively straightforward. But you also have moral rights, which again need to be waived. And then the right to record is actually a non-property right, and that also needs to be waived. So if you are, it's quite complex, so I won't go into the details, but if you are looking at rolling out recording training sessions or lectures, there are a whole load of sort of practical points you need to think about, not least possibly consents if you've got individuals on there, DP issues around if individuals can be identified from that, and also waivers in the context of academics or any individuals that are involved in the recording. So it's just something you need to think about in your contractual arrangements with them.
But since we've got just the one, I'll
Yes.
throw it at you if I may, which is just a question about domain names and whether it's possible to challenge the registration of confusingly similar domain names. I suspect you're not going to go into detail about the various mechanisms for doing that, but the answer, if I'm right, is essentially yes, isn't it? You can.
It is. It's not something I've done, no, Shivaji. It's not something I've done.
Okay.
It is possible, and there's a separate procedure for that. So if the anonymous attendee wants to get in touch with me afterwards, I can put them in the right direction and let them, because there's a separate procedure.
Absolutely. And I know that Ben Holt and his team have done that quite regularly. Okay.
Yeah.
Good. So we've had a look at trademarks, had a look at copyright. Did you want to say any more about copyright protection and some of the things that you need to do?
Yeah, practical tips maybe. Yeah. Thanks, Amy. So as I mentioned, there's no system of registration in the UK, different position in the US, but we're not dealing with the US. I get asked numerous times, and often I get phone calls from individuals who've developed a piece of copyright work, published works, and they say, is it correct that you post it in an envelope to yourself and then you can record it? Well, actually, that is a way of doing it, because effectively what you're doing is recording the exact date it was created, and then that's evidence of creation and the date of creation. So you can do that, but it should suffice to complete. Obviously, in today's day and age with computers, it should suffice as long as you've got a detailed design record. So one way of doing that is use of copyright notices. So the details of the author on it and the date and the copyright notice, and also the other thing I would recommend is using the copyright symbol. Whilst it's not legally required, it has a deterrent effect. So makes it quite clear to any potential user that you're taking your copyright seriously. And also in relation to any potential claim for copyright infringement, it's relevant to an argument that of innocent infringement. So it's relevant to the damages claim.
Brilliant. So some practical things that people can do. And then I think, so we've had a look at those two rights, or trademarks, copyright. You said earlier that we would whiz past some of the other rights, including patents, which are less often a practical concern for most charities. Are there other rights that you'd just like to briefly touch on?
So just briefly, Amy, next slide, just briefly touch on designs. So as I mentioned, designs, I will just briefly, so that you're aware that there's a regime of UK registered and unregistered rights. They're time limited. I won't go into details as to the time limits. And this is going to be quite unusual. If you're involved in the manufacture of products, or you design something that you think has a particular design that is novel and it might attract protection, then I'd recommend you look at registration. But to incur the expense of doing that, you'd have to be something that's more central to the charitable organisation. So I suspect it's something that you're not going to want to do. But if you do, it's something you need to look at. So patents, I think the majority of charities who actually have large patent portfolios will be all over this. But for those who don't know, patents effectively protects inventions. I do a lot of work with universities, so they do a lot of R&D research, and they'll have the whole patent portfolio protected. Again, it must be novel and capable of industrial application. And if you do think you might have a patent, it's absolutely imperative that it's not made available to the public, because that will impact on its patentability. So a lot of my clients, we have a whole range of NDAs that we use for them to make sure that if they are going into business or collaboration with anybody, because, for example, they've got the patents and they want to get it to market quickly, then they have a manufacturer in place and they want an NDA. It's absolutely imperative that it's not disclosed, and these rights last for up to 20 years. But I won't go into patents in any detail. Have you got lovely? Yeah. So this is confidential information. This is something that every organisation is going to have. It's going to be your trade secrets, your know-how. It's going to be very much aligned also to those companies that have, or those organisations that have patentable inventions. So this is something that we can manage. I would always say to clients, don't ever go down. This is another litigation matter I had years ago where we struggled with actually getting to court because of the evidence required. So really, you don't want to be litigating on this. And the top tips I would give in the context of any, even if you've got a perfectly drafted NDA by two lawyers who think they've done a brilliant job, always try to look at restricting circulation of if you've got very, very confidential information that you do not want to reveal to a competitor, or you do not want to be in the market, just make sure that you restrict its release. Marking everything as confidential when it is genuinely confidential is also very important. And then the other thing is the contracting your employee contracts. Make sure you've got confidentiality provisions in those to ensure that all your employees are aware that there's a duty in there to keep things quiet. So I think that's probably it on.
That's really helpful. So if I've understood you correctly, that the protections there, the tips in that bottom section, are almost in the order of effectiveness. First thing, don't restrict access, so you don't have to worry about enforcing your rights. Yeah. Secondly, avoid some practical tips of mark them as confidential, and then thirdly, some contractual constraints that you might then have to enforce. Brilliant.
Two others I've not mentioned actually, and one that our attendee raised. Domain names is another one. I think it's really important from the outset to try and secure as many. This is core to your brand management, really. Make sure that you've got all the domain names you're interested in, and if they're taken, you can look at buying them. I had that recently with a former client who actually effectively made an offer and bought some domain names. So don't neglect domain names, and making sure that you've got the domain names you're looking for, and if needs be, have a little battle for them if you have the grounds to do so. And the other point is database rights. So database rights do exist separately of copyright, and they can arise when copyright doesn't. For example, you don't meet the minimum threshold to attract copyright protection, because database rights are not they're not particularly they protect things like yellow pages, Shivaji, or but nevertheless, in the context of charitable organisations, I think that they're relevant. Maybe your donor lists.
Absolutely.
And the rationale behind these is to basically to protect time and investment that people have invested in creating the databases. They last for 15 years, broadly 15 years, and then if they're updated, then it'll run on.
So if you put a lot more effort in, again, to reorganize the way that you're holding your data, or to change it a bit enough so that you've got a new database in effect, you can stretch that right beyond 15 years and get a longer period of protection.
And I think it's come out because historically there was a problem in terms of attracting copyright protection for these databases. Yet there was deemed to be a value because of the creative effort that went into developing them. So I think that was it. I think I covered it.
So yeah, and I think you have. So you've identified some key areas for finding and then managing IP. We've looked at trademarks, at copyright, and at confidential information as being the ones which are most practically relevant to most charities, with things like patents and design rights in the background, which people need to be aware of, but are likely to be more specialist. So I think that moves us on to a question about what are the key considerations for charities when it comes to protecting and then managing those rights.
Okay, so we've identified the rights. Well, we think we own them, but actually, do we really own them? So that's the first thing. Do we really own them? So copyrights is owned by the author and the first owner of the copyright, but there's an exception to that, which is in the context of employment. So section 11(2), I think it is, of the Copyright Designs and Patents Act, which is referred to on the slide there, makes it very clear that your employer is the first owner of the copyright in any works. So you have to ensure that when you have an employee, it's very, very clear. This only applies during the course of their employment. So you need to have that expressly set out in their employment contract. So, for example, Shivaji, you have one of your employees who's allocated to a particular project, and it's a special project, and it's not actually part of their day job. I think in that sort of situation, we need to be careful that a separate assignment of the IP is made to.
So when we were discussing this earlier, Sarah, we used an example, didn't we? So my wife happens to be a dancer, a choreographer from time to time. And if you're working within an arts organisation, it's not unusual to have a collection of different creatives coming together for that organisation at the time. but also dealing with a range of their own projects outside hours. And what you're saying is, although probably in most cases the board is aware of that artistic activity, it might well be the reason they've employed those individuals. At the same, and they probably feel very positively about the mutual benefit of the organisation engaging in a variety of different performances, productions, but also having other people involved doing their own thing. There might be areas where there's the distinction between the two is a bit grayer, where the work being done by individual employees outside hours is actually heavily overlapping with the work they do in their role as an employee, and perhaps even sometimes is being conducted in the same space at the same time. So they might say, well, I don't work after 2 normally, but I'm going to hang on here and do some work, perhaps even use some of the resources of the organisation. And unless you've been clear enough about where the boundary lies, and unless there's been clear documenting about what permission has been given, then there might then be cause for a dispute about who owns the copyright. Is that right?
Absolutely correct. And it's been over the last few years of my experience, there have been a number of debates around, is this within the course of your employment? Is it, or isn't it? So I would just emphasise the need for absolute clarity around the boundaries. You're absolutely
And of course, we're each today sitting outside our offices. You're very visibly there in your kitchen. I'm up here in the spare room. And the work that we're all doing, and that many of the people listening today will be doing, blurs that distinction between the usual course of employment and sitting in the office and home life. So these issues are likely to be harder to manage.
Exactly, increasingly a problem. You're absolutely right, Shivaji, you're absolutely right.
Okay.
So then the other thing is you have your contracts with consultants, subcontractors, and I would just, suppliers, just ensure that all of those contracts have any IP. So they develop a piece, they develop a logo for you, they develop some marketing material for you, they contribute a section to the training materials based on their expertise. Just make sure in your contracts with them that you have an assignment of the IP back to the organisation, so that it's sitting with you and it's an asset that's sitting within the charity. Volunteers is another area as well. I mean, and this, you can imagine it, you just think it's quite relaxed, but ultimately you have a volunteer who goes off and then the charity becomes well known, and they say, well, actually I developed that logo, but you were volunteers, and there was no contracts, they were just coming. So it's very important that, particularly when the volunteers or any of the individuals involved in any creative endeavour, that you have the assignment in place.
Because otherwise those volunteers may themselves own the rights.
Correct.
Because they created the item as individuals.
Outside of the employment. Yeah.
And I think I mentioned to you that I have an experience with this going on at the moment for a client that is a faith body, and they're having an internal dispute between 2 different faith bodies about who should have control of the name and logo they happen to use across the movement, so across several charities in that area. And there was a trademarks hearing in the registry, and one of the key issues being raised was the idea that the other side actually owned the rights to the mark concerned, because they said it had been assigned to them by the volunteer who some 16 or 17 years ago had actually drawn the name and logo, or the logo, for the organisation. And in precisely the sort of way you're suggesting, the circumstances in which that took place and what was intended at the time about who would own the copyright was the source, and is the source, of some contention and a lot of uncertainty. And I know that the individuals concerned with that have done a little bit of kicking themselves and thinking it would have taken 5 minutes back at the time to
hindsight,
quick exchange of email. Isn't it just? But I think that's the issue that you're highlighting.
I didn't know
a bit of record keeping.
Sorry, I didn't know about the details of that, Shivaji. So collaborations and partners, again, invariably in this situation, you might well have both parties bringing something to the table in terms of IP. Somebody brings a brand, somebody brings some know-how, someone brings some expertise. And I think my advice here would really just make sure you ring fence what you're bringing to the table, make sure that your background intellectual property, which is what we call what the parties are bringing to the table, the parties identify that from the outset, so it's clear. And then it might well be that some licensing arrangements are needed for the project or the collaboration to work, so cross licensing around the background IP. And then during the collaboration period, there's going to be some foreground IP developed, and thought needs to be given as to who should own that, because there are loads of different factors to take into account. And again, this is a whole different webinar probably, but things such as who has got the money and the time and the resource to enforce it if there's any infringement of the IP, who can maintain it if there are any patents or trademarks that need maintaining, who has the funds to do that. But as long as each party, my advice would always be for the parties to agree between themselves from the outset, before instructing the lawyers to do the drafting, because if you can't go in commercial terms, the drafting makes no sense. So I would always advocate getting it clear commercially what you're trying to achieve with the IP, so you get a license to use what you want to use out of the foreground, and they do as well. So that's my point of collaborations. Licensing arrangements, I think, Shivaji, this is my point where I need to sort of defer to you really, because invariably within a federation, a thought needs to be given. I think this is back to my earlier point around where the IP should be sitting and where the licensing arrangement should be coming from. And there's a whole different
yes, I think what we talked about was the fact that, as you mentioned earlier, there are often decisions about where intellectual property should be owned. So it might be that the name and logo are registered by the charity itself, but that lots of the exploitation of that, whether that's through cause-related marketing, sponsorship arrangements, or through licenses out to third-party manufacturers, all of that might be undertaken by a trading subsidiary, because, and it might well be necessary that it takes place through a trading subsidiary because it's non-charitable activity, non-charitable trading activity. And in each of those cases, what occasionally is overlooked is the need for the charity itself to have licensed to its subsidiary the rights that then will be licensed on. So there's that piece. And then alongside that, there is the piece that many of the organizations we work with, and many of those represented here, will be much more complex than a single legal entity. And federations are a great example because they are often very complex in that you might have hundreds of separate registered charities. And in that context, it'll often be the central body within the federation that registers and protects the rights, but then licenses them out into the individual member charities. And of course, there are variants of that. It might be a network of churches, it might be a university and its various constituent halls. And in each case, there needs to be a clear record of where the intellectual property sits, where it's licensed out to, and the terms on which that is done. So that's a very quick overview, but I think that's where we get to.
I thought of one extra point actually, Shivaji.
Go on.
Funding. Just always check where your funding is coming from. In my experience over the years, funding agreements have different provisions in them in relation to what you can and can't do with the grant-funded IP. So just make sure you're not flouting that. They usually have brand guidelines in there as well to ensure that they have some recognition for the contribution. So if you're subcontracting, that needs to be flowing across and coming out into your subcontracts as well. So it depends on who the funder is, but there will be provisions dealing with IP, and it's just make sure you're familiar with them, and that the individuals dealing with the contracts are familiar with the necessity to put my teeth in to flow them across. Absolutely.
Okay.
Shivaji, I think it's my turn to ask you some questions now.
Okay, go ahead.
I've done my bit. So, duties of trustees, Shivaji.
Yes, and thank you, Amy, for giving me the slide there. So you're absolutely right. A key element of this is thinking about intellectual property in the context of the wider picture and the duties of the charity trustees. And a starting place is the Charity Commission's guidance that's summarised on that slide, which is that intellectual property rights, including, as the slide says, the name and reputation of a charity, are valuable assets. Like any other assets, the trustees must therefore be protecting them and acting prudently in doing so. And they then need to think a stage further and think about their governance role and how they ensure that they have effective oversight of the various relationships that a charity will have that involve those assets. So partnership agreements, joint working with other charities, exploitation through the sort of fundraising methods we mentioned earlier. And in each case, they'll need to be able to show that they've made the right decision for the charity in terms of the use of those important assets. And then that I think leads us on to just 3 other points that I wanted to make. The first is that sometimes that fundamental duty, which we're emphasizing as a way of saying, do protect your intellectual property as an organization, has to be balanced against other duties. And the clear example there is, you mentioned research charities and the fact that they might want to patent some inventions, and that if they patent inventions, that they might need to ensure that they're not published prior to the application, because they want to, because that would prevent them from being able to secure the registered right. And of course, that directly balances against the charity's desire, perhaps, to disseminate the useful results of research. And so often there'll be quite a complex balancing act to decide which areas of the research can be disseminated, and where the future benefits of either generating income or exploiting a patent in other ways to deliver charitable outcomes, which might be by securing the rights so that, for example, a medicine can be spread more effectively, can be distributed more effectively. Any of those things will need to be balanced quite carefully. And while it's clearly beyond the scope of this session to talk about the detail of that, boards do need to have a think about the strategy they adopt in considering those issues. They then need to be aware, I think, that there are some specific provisions in charity law that help when it comes to protecting the name, the reputation, or other assets of the charity. And so, for example, there are specific powers to prevent unauthorized fundraising. And charities will occasionally use those powers to prevent, for example, cause-related marketing which hasn't previously been approved by the charity. There are, as you'll know, rules like those around commercial participation that I regularly fulminate about, because they're not very well known and not very well enforced, but it does mean that we have charities that find that they are seeing a product sold in their name, but only receiving a very tiny proportion of the proceeds, and sometimes only realizing that they're getting the proceeds when they receive a check, and not as it should have been at the point when the relationship begins, when they could have put a contract into place. And then finally, the kind of third point was around the Charities Act 2022. We talked about the names of organizations. There are some provisions in the Charities Act already, so in the Charities Act 2011, about applying to the Charity Commission to say that new charity that you're about to register is being registered with a name that's too similar to our own name, our charity's name, and so we'd like you to stop it or order the charity to change its name. And that can be done, but there's a time limit, there's a 12-month period. And at the moment, the rules only allow you to do that whether the name being used is similar to your registered name as a charity, your legal name, and it doesn't extend to the working name, so any name under which the charity carries out its activities. The 2022 Act, the one that recently came into force just in the last month or two, and which will be being implemented over the next 18 months, we understand from the Charity Commission, will both extend those rules to working names and also extend the time during which the Charity Commission can be persuaded to act. And there are also some additional quite useful powers given to the Charity Commission to, for example, refuse registration or to delay registration while these things are managed and dealt with. So there you go, a few points about the role of the charity trustees. And I think you were then going to move on to thinking about, very quickly, brand management, with the aim that we'll have a look at that on your couple of remaining slides, I think, and then we'll have a look back at some of the developments that are coming through.
Thanks, Shivaji. So these really are just more tips, really, I think, for the key points you need to be thinking about.
Okay.
And probably cover what we've already picked up and just emphasising for good measure. So make sure that you register in key territories with trademarks, and make sure you've got your coverage cross classes. I can't emphasise that enough, really, based on my experience. I know it sounds really obvious, but keep renewal fees paid up to date. Make sure if you are going to have registered rights, you've gone to the expense of making sure that you've got the registrations in place, make sure that you keep them renewed when you get your reminders through, and or if we have a member of staff leave, make sure somebody else is picking that up. Consistency of use around brands is absolutely, it is really key. So if you are granting licenses to partners to use the brand, make sure that you have brand guidelines in place, so there's no dilution of the brand, so the impact of the brand is not lost. I know it's only, might feel like a small thing, but it's very important, and make sure they're kept up to date. Back to the use of symbols. Do not use the registered trademark symbol unless you have a registered trademark, because it's a criminal offence, and it's about, I don't know what the fine currently is, it was about £1,000. It's pretty, I know you could do without having that, but otherwise you can use, I would encourage you to use the TM mark, because it's just indicative of use of a trademark, and again it makes it very clear to the reader that you are live to your IP and are on top of your IP. Again, register relevant domain names. I've already covered that, I think, and use the copyright symbol. I've already covered that. Check ownership of the copyright in your logo. I think we've had some cautionary tales around that. Make sure you own it. A number of clients have outsourced to design agencies, and then the brand takes off, and suddenly the design agency comes back, and you find that they think they own it. And not only do they think they own it, they've authorised another third party to use it, who's using it in parallel. So that's something to caution against. And then I think one of my, it's not on the slide, but one of the key things, the big bugbear of mine, is about record keeping. So I was presenting at the tech sector in a tech sector conference the other week, and actually I think it's so important that from early stages of development throughout the life of intellectual property, that we keep records, so that you've got a record of who owns what. You know, in my experience, when people move on, you need to have that, you need to be able to refer to that, talking about your situation, the case you mentioned around the faith group, Shivaji, as well. So keep a record, keep a log. Education internally. So have an IP policy. If you haven't got an IP policy, it can be simple, keep it updated, just so that your employees and the staff and individuals, everybody's aware that you have an IP policy in place, that you're going to keep on top of your IP, that everybody knows what IP that the organisation has. The brand guidelines are a part of that. And then also, if you're going to register IP, or if you're going to protect your IP, you've got to put your money where your mouth is, and really you need to be proactive within your enforcement policy. And if somebody is infringing it, okay, you'll need to do a cost benefit analysis, but invariably, I think if you're going, and I don't know if you would agree with me on this, Shivaji, but really I think enforcement or actually it's got to be policed effectively. That's very important.
Absolutely. And I think it's an important question or important discussion that we often have with clients who need to balance the desire to protect all sorts of potential rights and to be really careful about those, against the fact that perhaps they haven't really got the energy or the funding to enforce all of those rights. And if that's really the case, then sometimes they need to think twice about whether registration itself
That's
is
absolutely
worthwhile.
right. I think my advice the other week to a client who's got a portfolio of patents was, you need to pick your battles. Pick your battles within that, and those that you can afford to support. So,
okay, excellent. And I think then moving on to our next slide. Is that right? Yes. And so it's an opportunity for anyone who hasn't done so to throw a question into the Q&A. And in the meantime, I'll just make a couple of comments about some things that we're seeing come through, which seem to suggest perhaps areas of attention. One of those is one that Sarah mentioned earlier, which is that since 2019, trademarks no longer need to be capable of graphical representation in the same way. And one of the things that's come out of that is that there have been a series of animated marks that organizations use. And I think even now you've seen some charities with animated trademarks. What I've popped into the chat is a link to the first of those that came through and was registered in the UK, which was a mark from Toshiba that's got a very twinkly animation associated with it. And it's worth just bearing in mind, I think, it's a reminder that actually trademark law enables you to protect all sorts of things, smells, motions, that old tapping the nose sign that we had, the jingle of Direct Line. So sometimes it's worth thinking twice about whether there are areas where you might protect rights. Second thing was a piece about the fact that we're working from home. And as Sarah again mentioned earlier, there's a piece about deciding what's in the course of employment and whether sometimes the boundaries between what is done as part of your job and what is done in your own time blur just a little. And we've seen a lot of queries, I know, to our employment team about the implications of that change. It's worth just bearing in mind that there are some intellectual property implications of that change and of the increasing working from home, including just the challenge of maintaining records where people are doing work outside the office. And so it's worth giving that some thought. I've mentioned the Charities Act 2022 and the new rules are in relation to prompting the Charity Commission to change names. I'd also highlight something more general, which is if we go back to what Sarah said about copyright and about the circumstances in which you might acquire the right automatically, there's an interesting case involving an American photographer and the animal rights group PETA, in which, in fact, there was a case taken before the American courts. I'm not going to pretend to have any knowledge of the details there. I'm not a qualified lawyer in terms of the American jurisdictions. But what was interesting is that they had a scenario where the photographer had carefully set up a camera, and in the event, a monkey hit the button to take the picture. And the court was asked to rule by PETA that the copyright resulting should be owned by the monkey and not by the photographer. Now, they didn't get the result they wanted that time. And I'm not here to talk about the pros and cons of non-human ownership of copyright or indeed of other rights that non-humans might have. But I think what's really interesting is it just reminds you about the slightly odd ways in which the rules around copyright can play out and the need to think about the defaults. It may be that there aren't any monkeys associated with the production of copyright around your organization, but it's quite possible that there are volunteers you haven't thought about, that there are self-employed consultants that you hadn't distinguished from employees, or others who are involved in the production of work that you might later want to exploit or to protect. So that's
extremely topical, actually, Shivaji.
Is that right?
Yeah, so artificial intelligence is the I've written a couple of articles on it. So it's about computer generated rights, who owns the copyright in computer generated works.
Right.
So we've got robots coming in, and there's a big movement to try and copyright law is going to be changing around this, because at the moment, I think the case, there was a patent case, I think it was called Thaler or something like that, and it was around whether or not this computer generated works could be owned by the computer rather than whether they weren't a human. And actually, as it currently stands, that they have found that it can't own a patent because it's not a human being. But it's certainly something that needs to be looked at, particularly with these NFTs coming, the non-fungible tokens.
Non-fungible tokens, indeed.
Yeah, which I'm not going to pretend to be an expert on.
So I think I did have that on my list, and that was simply to say, without going into the pros and cons of NFTs, or indeed exploring any length what they actually are, say that if people are creating unique items to distribute electronically, that leaving aside the debates about the pros and cons of cryptocurrency that's often used to pay for these NFTs, leaving aside the various other debates associated with them, there's a really simple thing, which is that there have been a series of copyright disputes because people appear to have believed that because they're creating an NFT, and there's this air of mystery around NFTs, that the usual copyright law won't apply in that context. And I think most of them have discovered that, in fact, it does apply.
It does still, yeah. They're looking to amend it, but it does.
And that perhaps they should have thought twice before using a work that was someone else's copyright in trying to create their NFT. So there you go, there's a few thoughts there.